everybody. So, I recently I was well, everyone knows I was arrested at Commissioner's Court, right? And I was thrown into a wall and whatnot, right? I was arrested. I was in jail for 7 hours, 8 or 9, 7 or 8 hours, 7, 8, probably 7 to 8 hours. I was or 9 hours. I was in jail, and I thought I was gonna have to bond out again, but then after that, I was released with a ticket, right? And I ended up getting revoked. I had a bond revocation because they were wanting to revoke my bond, and it was my bond was revoked because of a statement that was put out by Bill Wayborn that I had caused a disturbance, and I'm gonna read that to y'all right now when I find it. So I have it. So y'all just bear with me. Promise y'all gonna like it. So there. Okay, well, he had stated that he released a statement. Let's see if I can find it. Okay, I found it. My bad. Sorry. It says on, and it's on the press release. Y'all see it? Oh yeah. Okay. Well, anyways, right. It says on Tuesday, January 14th, during the regular scheduled Commissioners Court meeting at 100 East Weatherford Street in Fort Worth, Texas. Two people were arrested for disrupting the court proceeding. One was Mr. Herms, a Tarrant County resident, made an outburst at the beginning of the meeting, prompting Tarrant County to issue a warning that any more outbursts would be met with immediate removal from the courtroom. Herms disregarded the warning and made additional comments that disrupted the meeting. Subsequently, he was removed from the courtroom. He's been charged with disrupting the public meeting and is being held in Tarrant County Jail. During a separate confrontation, Manuel Mata, also of Tyrant County, began recording the argument with his cell phone. He aggressively demanded the names and badge numbers of the deputies that were present. He continued his disorderly behavior to the point that the court had to be shut down. As a result, he was arrested and charged with disorderly conduct. Commissioner Court has an official decorum that individuals must follow while attending court, said Sheriff Wayborn. Public comment is welcome, but it must be limited to the posted agenda, the business of the county, and must be made at the appropriate time. We are always respectful of our citizens who attend our meetings, but we do require they follow the rules and return the same respect. Yeah, I know it's not a court. They're stupid, but that's what they call it, commissioner's court, right? So I was arrested, like I was saying, right? And it turned into a ticket. Well, I've been trying to get, okay, I was arrested, turned into a ticket. And then my bond, they were trying to revoke my appeal bond, right? Because like I said, me and Carolina, our lives, our videos are being watched by certain people, right? Prosecutors, investigators, chief of investigators, Salinas. Yeah. So they saw this statement that was put out by Bill Wayborn, and they put a motion to revoke my bond. So I had to get CJ to defend me, right? And what happened was CJ couldn't defend me because he became a witness, right? So what happened was I got another attorney, right? And during that court, I didn't like what I was hearing because it went from that statement, that press release for my reason being in court, to them showing a memorandum that didn't make me the problem. It didn't make me the one who disrupted the meeting. See, what they wanted to do was get CJ on the stand and try to perjure himself or admit to being they were trying to get him to impersonate a law enforcement officer, right? Because he's stating all these codes and all that, and they applied to him because of his situation and circumstances. Nothing he's saying was illegal or a lie, right? So that's what they were trying to do. So I didn't use CJ as a witness because I didn't want him on the stand. So that never happened. But I wanted to get, they used two exhibits on me, Exhibit A and Exhibit B. Exhibit A was what I just read to you, the press release from Bill Wayborn stating that I was, what I wanted was Exhibit B, which stated that the only reason that this whole thing blew up how they said it did is because they used a post that was made bringing awareness to Mason Yancey. And he what they did was got that post because it was a post that they put on someone created an event and said, hey, we're coming to address our course and our displeasure of what happened in your Tyrant County Jail, what happened to our friend. So they used that post to say that 150, like I think 150 or some of people ended up saying they were gonna come, right? Never happened. Never happened. If any, there was probably 40 people because most of the people were there to support his family. You know, they wanted to be there and show their love and the respect for Yancey because what Tyrant County likes doing and the sheriff likes doing, he likes dehumanizing and demeaning people that are unalived in his jail. But when it comes to his, it's a different thing, you know. It's not the same because it's my kid, you know. He can commit any crimes he wants to, whatever, I don't care. You know, but that's not here nor there. So that whole situation was like they said that because of 100 people were coming and they assume, I'm going to use assume because if I say lie I have to prove that it's a lie. So they assumed that 150 armed people were coming to the commissioner's court to protest. Now mind you, this is what was put in the report to try to get me locked up and put in jail, right? Because I was arrested for disorderly. But in that same report that they put out, they didn't put me as the person that was causing the disturbance. The disturbance was created by my attorney, right? Who they were going to try to get him to entrap himself on the stand. And that's why I requested to get that information. And they chose to what I knew they were going to do. They were going to say, no, 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 no. So I wrote them and I told them because they used it. And I agree that what they're using, because those are um, codes that are used to keep certain investigative things secret. But remember, confidential and secret. That means it's not used in a public manner. So what happens when they use this secret or confidential information in a public courtroom? Because now you're using information that was supposed to be secret and was supposed to be confidential, but you're using it in a public forum. And I have the right and I have the ability to request any information, any person that has used against me. So that's what I did. I requested the both exhibits that were used because they didn't get it. They lost on disorderly and they tried to do something else and they lost all the way around. The only thing the judge gave them at my bond revocation hearing was the fact that they kept that he admitted defeat. He knew he was full of shit. He knew this was a stupid reason to be waste money and be having anyone in court. So he resorted to the 25-foot rule that is put on us because we're on bond probation. And that means I can't be 25 feet within from a police investigation. Law enforcement investigation is what they interpreted as now. So anything that they even said, if it's happening in front of me in a building, I have to leave the building. So like this situation, right? So in future references, if something's happening in a building and I walk up to film it, I am in jeopardy and I am going to get arrested because I'm 25 feet within a law enforcement investigation. So that's all that the judge gave him. He wanted 25,000 for my bond. The judge took leniency, you know, and said, no, bro. And he charged me $5,000 to get out. They paid, I got out. So now I'm trying to get the set information that was used against me in a court, which it's a public record now. You can't say it's confidential or it's whatever because you didn't keep it in that thing. You used it and put it in a court proceedings to try to get me arrested, locked up because he wanted 25,000 and the judge gave me $5,000 bond to get out and I did. So this is their response to it, right? So remember everything I just said to you, how they used it, right? They took a post that said 150 people were coming to demand justice for Mason Yancey, right? Because he's a 2A auditor. And that's what they assumed. They assumed, remember, I'm using assume because if I call them liars, I have to prove it. And they're refusing to give me the proof to prove they're liars. So they're assumed that 150 people, armed people, were going to come and protest. And the only person who showed up with a weapon were all the deputies, all the top flight securities, and my attorney. But they were all legally able to hold them. They were all legally able to carry them. And it's been proven. And then they know that. They just choose to do certain things. So I'm gonna read you their and mind you, today is the last day for them to give me my stuff. So they waited the 10 days. Because they're saying yesterday, even though it's not a recognized holiday, it's been scheduled. Look, I'll tell you. I'll read it to y'all. Okay. It says Public Information Act request from Manuel Mata to the Tarrant County Sheriff's Office seeking reports and memorandums associated with his arrest. On March 18th, right, the Tarrant County office received a public information request for Manuel Mata for all offense reports and memorandums associated with my arrest on 1/14/25 with the report numbers 2025-00472 and 2025-00477. This request was submitted through the Tarrant County Public Information's online request portal, and the date of receipt is reflected near the top of the request notifications, right? Pursuant to Texas Government Mode Section 57552-0301 and 552-309, a request for a ruling to the Office of Attorney General is timely submitted on or before April 2nd because this request for a ruling has been submitted to the AIG and the request on April, it is therefore timely. The Tarrant County, now pay attention, the Tarrant County District Attorney's Office, a legal counsel, and on behalf of the Tarrant County Sheriff's Office seek to withhold some of the requested records pursuant to Texas Government Code Section 55-101 in conjunction with Section 48-182 of Texas Homeland Security Act. Texas Government Code Section 552-1078B1, Texas Government Code Section 552.108A1, and Texas Government Code Section 552.111. And it says on Monday, March 31st, 2020, all Tarrant County offices were closed in observance to the Cesar Chavez Day. Although Cesar Chavez Day is not a state or national holiday, substantially defined in Texas Government Code section, the Tarrant County Commissioners Court approved a holiday schedule for fiscal year 2025 on August 2024, designating March 31st as a non-business day for purpose of Texas Government Code, whatever. So that's the first part. It's 6 pages, so just chill. I'm going to read them all to you. It says 1.1. The request document may be withheld under Texas Government Code section in compliance 552.101 in conjunction with Texas Government Code section 418.182. Section 552.101 expresses the disclosed information excepts from disclosure information considered to be confidential by law, either constitutional, statutory, or by judicial decisions. This section encompasses other statutes that make information confidential, including Section 418-182 of the Texas Homeland Security Act, the HSA, and Chapter 418 of the Texas Government Code. Section 418.182 provides in relevant part information in the possession of a government entity that relates to the speculation, operation, procedures, or location of a security system used to protect public or private property from an act of terrorism and related criminal activity is confidential. Texas Government Code 418.182A, the fact that the information may be related to a governmental body security concerns does not make such information per se confidential under the HSA. See Open Records Decision number 6489 at 3/1986. Language of confidentiality provisions control scope of its protection. Furthermore, the mere recitation by a government body of a statute key terms is not sufficient to demonstrate the applicability of claim provision. As with any exception to disclosure, a governmental body asserting one of the confidentiality provision of the HSA must adequately explain how the response records fall within the scope of the claim provision. Government body must explain how claim exemptions to disclosure applies. Regarding the current request, the respondent's documents include an internal memo between Tarrant County Sheriff's Office staff and incident reports regarding related events in which the safety, security, and control of the activities were discussed. These documents discuss firearms being brought to specific government buildings, locations mentioned in the memo, and reports are details regarding security measures such as metal detectors, credentials, lock boxes, use of restraints, security personnel, and their strategic locations and positionings, coordination with other law enforcement agencies, and communications and protocols dealing with safety and security. The discussion also concerned the large number of attendees probably appearing for the event. I'm going to say that again. The discussion also concerned the large number of attendees possibly appearing for the event and the anticipated actions of the attendees, and a related discussion about security personnel and the number of staff members needed in order to ensure safety, security, and order at this event. The documents also include supporting documents gathered from intelligence officers regarding the potential threat of safety and security during the events. The discussion revealed the ability of law enforcement to identify such threat, what tactics are used to gather intelligence, what resources are available to TCO to respond, who would be armed, operational plans, what precautions and responses are likely to be employed, signage posted, the actions taken regarding detaining, which is all information relating to operation procedures used to protect public or private property. The government building in which this event was to occur from an act of terrorism or related criminal activity, such as using weapons and firearms during a protest at a public event. Further, the document at issues contains information regarding the location of security personnel, location of specific rooms used by staff members, methods of communications by security personnel. The documents in questions also include discussions regarding verification processes used and discussions about verifying status of peace officers. The release of responsive documents will reveal the protocols, procedures, strategies and tactics available and utilized by Tarrant County Sheriff's Office intelligence officers in maintaining safety and security of everyone in attendance at a public event where protest is anticipated. Additionally, the release of this type of information could be used to identify and exploit weakness in the county security system inside the county's in the county's buildings discussed therein. Under these circumstances, the Tarrant County District Attorney, on behalf of the Tarrant County Sheriff's Office, seeks to withhold the responsive documents pursuant to Government Code Section 552.101 in conjunction with Section 4, whatever, right? Exhibit B. Some of the requested document may be withheld under Government Section 552.101B1 from disclosure the internal records and notations of law enforcement agencies and prosecutors when their release would interfere with law enforcement and crime prevention. See Open Records Decision number 531 at 2, 1989, quoting Ex parte Pruitt, 551, Southwest 2nd District, 706, Texas, 1977. A government body claiming section must reasonably explain how and why the release of the requested information will fulfill when law enforcement is intended to protect information with, if released, would permit private citizens to anticipate weaknesses in a police department, avoid detection, jeopardize officer safety, and generally undermine police efforts to effectuate the laws of the state. And this is a stupid law that they use because they passed it. It's the city of Fort Worth versus the city of Fort Worth versus CORNYN, Texas Appeals, Austin 202. The Office of Attorney has concluded Section 552.108B accepts from public disclosure information relating to the security and or operation of a law enforcement agency. Open Records Decision number 531. Release of detailed use of force guidelines would the release of detailed use of force guidelines would unduly interfere with law enforcement. And then they used another one, which was designed to protect investigative techniques and procedures used in law enforcement. Disclosure of certain operations or specific equipment directly related to investigations or detection of crime may be exempted. If not applicable, however, to generally known police, it is, but Section 552.108B1 is not applicable, however, to generally known policies and procedures. Man, these little letters are small. These letters are small. I could make them bigger. Okay. Government body failed to indicate why investigative procedure and technique were any different from those commonly known. And this is their explanation. Here, the responsive documents discussing the concerns, precautions, supporting information gathered by intelligent officers and anticipated methods of handling dangerous situations that may arise are not generally known to the public, and the release of which would unduly interfere with law enforcement efforts by TCSO and their intelligence officers when planning security and safety precautions to keep the general public safe at certain public events. The responsive documents also discuss what actually occurred, what tactics were used for security and safety. Now I'm going to say it again. and their intelligence were planning security and safety precautions to keep the general public safe at certain public events. The responsive documents also discuss what actually occurred, what tactics were used for security and safety, the details regarding security measures and security staff, handling of weapons and protocols and procedures in action, cameras that are set up for security purposes. If these documents were to be released to the public, members of the public wishing to do harm at these type of events and endanger the lives of themselves or others would be equipped with special knowledge that the intelligence officers gathered and discussed amongst Tarrant County Sheriff's Office and could anticipate weakness and vulnerabilities in the plan, the preparations, the precautions, the limitations of actions that can be taken. The knowledge of the law enforcement officers anticipating potential threats and dangers. And to taking limits, threats, and dangers. Using that knowledge, a potentially bad actor could monopolize on this information and increase their chances at succeeding if they wish to inflict harm to anyone at such events. Moving forward in the future, it is worth noting that this event is a reoccurring event for the county. Tarrant County Sheriff Office objects to the release of the documents as they're related to safety and security practice in Tarrant County jails and contain certain sensitive law enforcement information related to the strategies and procedures and specific intelligence gathered by Tarrant County Sheriff's Office and their intelligence officers regarding the particular events in question, but as applicable to future events in similar nature. Thus, release of this information would interfere with law enforcement and crime prevention. And it says, under these circumstances, the Tarrant County District Attorney's Office, on behalf of the Tarrant County Sheriff's Office, seeks to withhold the request information to pursuing to go the government code section, the same one. And then this is the kicker, right? 3, a portion of the requested documents are protected by the attorney-client privilege and may be withheld from public release pursuant to section 552107. Although the Tarrant County District Attorney's Office believes the entirety of the submitted documents may be withheld, the Tarrant County District Attorney's Office additionally asserts that a specific portion, which has been marked noted, is exempt from public disclosure pursuant to section 552107 of the Texas government imparts a release of information if it is information that the attorney general or an attorney of a political subdivision is prohibited from disclosing because of a duty to the client under the Texas Rule of Evidence or the Texas Disciplinary Rules of Professional Conduct. The Texas Attorney General has interpreted this exemption to accept from disclosure information that falls within attorney-client privilege. The attorney-client privilege protects from disclosure confidential communication made per the purpose of facilitation, the rendition of professional legal services. Texas Rule of Evidence 503B1. In order for the attorney privilege to apply, the information must constitute or document a communication. The communication must have been made to facilitate the rendition of professional legal service to the client governmental body. The communication must have been between or among client representatives, lawyers, and lawyers' representatives. That the communication was confidential, not intended to be disclosed to third persons, and that the communication has remained confidential. That's the main one. That's why I wanted to get to this. That number 4, that the communication was confidential, not intended to be disclosed to third persons, and 5, that the communication has remained confidential, and it has not. So, and that's a ruling that was made by the Texas. It's a Texas Attorney General Order number 676 at 7 through 10, and it was passed in 2002. Further, it's important to note that the attorney-client privilege includes communication between the client representative and the client's lawyer representative, between the lawyer and the lawyer's representative, by the client representative or lawyer representative to a lawyer's representative or lawyer that represents another party in an pending action and concerning a matter of common interest therein, between representatives of the client or between the client and the representative of the client, or fine among lawyers and the representative representing the same client. Man, that's a crazy one. That's so crazy. And this is under Texas Rule of Evidence 503B, and then the first. For the purpose of the portion of the responsive document attached as Exhibit B, which has been marked and labeled as attorney-client privilege, the attorney-client occurred between an assistant district attorney employed by the Tarrant County District Attorney in the Civil Division and Tarrant County Sheriff's Office staff. The Civil Division of the Tarrant County District Attorney provides professional legal services to each department within the Tarrant County government and its respective employees, appointed or elected officials, including Tarrant County Sheriff's Office. The communications of Tarrant County District Attorneys asserts are protected by the attorney-client privilege under Section 552.01 between the ADAs in the Civil Division and personnel in other Tarrant County departments, such as Tarrant County Sheriff's Office, were intended to facilitate the rendition of legal services. The marked communication was made for the purpose of attending professional legal services from the Civil Division of the Tarrant County District's attorney's office and were not intended to be disclosed to a person outside of the attorney-client privilege. Outside the attorney-client relationship, and have remained confidential. How? If the sheriff's office was asking the DA for advice on a civil litigation, right? Whatever. What does that have to do with my court case, though? And that's crazy. So that's what they're saying, right? And they end it to the extent that the marked portion in Exhibit B consists of attorney-client privilege communication. The Tarrant County District Attorney's Office seeks to withhold these documents and portion of these documents under 552.102. The records sought to be withheld are attached in this request for a ruling as Exhibit B. This letter will serve as notice to the requester. The Tarrant County District Attorney's Office is seeking a ruling regarding the enclosed document. I can be reached at 817-884-1233 if questions arise regarding this request. Sincerely, Phil Searles, District Attorney, Tarrant County, Texas, And it has S. Paul Wynn, Assistant District Attorney. Attachments. Exhibit A, public information request. Exhibit B. It's crazy. Yep. And that's what these assholes said. Isn't that crazy? So if all that was supposed to remain confidential, why is it being used in a public court? Because nothing is confidential. Nothing is. Even discovery. Even discovery. Anybody can get it, bro. And what's happening is when I try to get you just run into a whole bunch of stupid shit. And that was my whole reason for saying all this, man. You know? So I'm gonna go back. Popeye's transparency. I hear you. Oh, Callahan. I don't know, man. It's crazy. That's what they call it. Cajun Randy, what's going on? Chris. I don't know how you can disrupt it. But that was my point. That's why in that whole thing, that exhibit B that they're trying to keep, it wasn't on me. That's why I need it. That's why I'm trying to get it. Yeah. Yeah. But I mean, look, their whole thing, their whole reason for doing what they're doing, getting money, getting shit approved, was a false sense of a threat, right? Because they stated in that, right, that 150 people were armed people were gonna come and protest and be around the commissioner's court, causing. None of that happened. None of that happened. It was proven a lie. So everything they say is a fucking lie. You know what I'm saying? And it's not true. Because no, still to this day, people go 2 day. They went 2 day. How many people showed up armed? None. How many showed up last Tuesday armed? None. How many showed up the week before? None. The week before? None. The week before? None. How many are going to show up in the future? None. So this is my point. This is why it gets frustrating. Because they lie on you so much. And when you need the evidence to prove it, this is what they do. I don't understand how the district attorney is involved in this now. That's crazy. But I've dealt with this before. I've dealt with them. The whole information request stuff. I've dealt with it with the forward police. So everything they're talking about, I know. That's why I stated it has to remain confidential. When y'all use it in a public courtroom, it's not private. It's not a private courtroom. No matter how bad y'all want it to be, it's not. You know what I'm saying? And and this is what I mean. I've even got it to where I can get the internal investigations they put in to where this is what they do now. You see what it says? It says right there in the black letters. That's what it says. Records pertaining to investigations that did not result in discipline are confidential. And then I kept going. I said, but it was. They did. It was sustained. They did get in trouble. So then they told me this. So it ain't like I ain't did this before. Like I'm slow or something, man. Come on now. Where's it at? It's somewhere in here. See out all these papers. It's somewhere in here. But that's what it says. Like if they get found, if their allegations are sustained, and if they give them a day suspension, they don't have to report it. They don't have to give it to you. They don't have to tell you. They don't have to release anything. That's why they do it like that. They'll suspend them for a day, and then I have to tell you. They just say your allegation was sustained. There were clear violations of policies and procedures that will be pushed up to the proper. Basically, they're gonna send it back to their supervisor, and the supervisor doesn't want to get a bad mark for his stupid ass cop, so they're gonna mark it like verbal reprimand a day with don't worry about it, don't do it no more, don't get caught no more, be smarter, man. Come on, man. They're watching us, stuff like that. So now I get to do the same thing with the Tarrant County Sheriff's Office, which I don't mind. I do not mind. I do not mind at all. I do not mind. And now the DA wants to get involved and protect them. So I hope the DA understands it now that you can't prosecute me right now. Isn't that crazy? Isn't that crazy? Remember, attorney-client privilege. So since you're protecting your people, you can't do nothing to me about anything right now. So the prosecutor and the little loser who's watching this, you heard? Because y'all know who y'all are. And y'all made it personal a long time ago. Long time ago, bro. You know what I'm saying? The fact that you sit here and lied and told me bullshit, I don't care no more. I've been through something the past 2 months that my understanding for bullshit used to be like up here. Now it's like way down here where my dick is. Like, I don't have none of it. I don't have no patience. I don't have no understanding no more. I don't have none of that. I'm not giving no one the benefit of the doubt. Fuck all that. Because the minute you do, that gives someone the opportunity to fuck you over, do you dirty, and just run all over you. So that's what I said. I told myself 2, 3 months ago, fuck that, it's over with. And that's why I wanted to come on here, is to let you know that the Tarrant County Sheriff's Office with the Tarrant County District Attorney's Office are in cahoots. They're in cahoots. They're in cahoots. Him need help. Him need help. And that's Wayborn. Bill Wayborn. Billy Wayborn. Our shitty sheriff. You know? Our shitty sheriff. But I bet you no one, everyone forgot where he came from. Everyone forgot that he had to leave another place. But they won't tell you why. Because people asked. They went to the city council meeting and asked, well, can we discuss about woo? We are not going to comment. We'll respect all your comments to legal. But you still have a sign supporting this guy to go somewhere else. Yeah, but we just can't. We don't want him here. We can't have him here. And then Tim O'Hare. Tim O'Hare. I guess he forgot the piece that the Forward Report, the Forward Weekly, KERA and all them that they did on you, Tim O'Hare, right? When you were a mayor for Farmers Branch, you cost your taxpayers $6 million. $6 million, right? Because you didn't want Mexicans in a certain area. And they told you it was wrong, immoral, and it showed your true colors. And what did you do? You did not give one fuck about it because you cost that city, I think it was for 8 years, 7 or 8 years, $6 million, where they finally told you, "Put your ass on." And it was because he was racist, because his policies, were racist. It's all in there. You can look it up right now. Former Farmers Branch Mayor Tim O'Hare. What I forgot what he says. forced to leave or something like that. But that's what it says. Mayor of Farmers Branch, Tim O'Hare. Look that up right now. Look it up. Yeah, but yeah, that's what I mean. But their codes are for them, but they don't even follow them. Oh yeah, I heard about that. Of this world is not the same as in this world. Just saying, listen closely to the games you're playing. So follow their policy and see how that works out. No, I'm not following no policies. No, these are dudes who release records. Like, no, no, no. Oh, I know about that. I've been knowing that there is no. I have no idea. Yeah. Pointed out to each other. So I look, dude. Who are you? Everything you mentioned in this chat was free to read, look up, learn as your duty, even to stay out of a cage. I understand what you're doing, and I'm starting not to care. Really. Thank you, Mary. And thereby what? Increased immunity by taking review and discipline of bad cops off the table and putting it in the hands of unions. Well, that's where we're at right now. Our whole city is run. Um, you're one of those dudes. Yeah, whatever. Um, that's crazy. In the hands of, but that's how our city is right now. It's ran by the unions because the police unions put money into campaigns, and five of our current seat holders in mayor and council got funding and are backed by the police officers association. So I already know they stacked the deck. I already know. You're not telling me I did like everything you can read, learn. That's the whole point of it. It's right here. I've already read it, learned it. I already did all that. I already did all that, man. And I don't have to follow them. My frustration is that they don't. I never said I follow them because I follow the law. I follow common sense. I follow myself because sometimes my shadow ain't there. So, but yeah, that was crazy. A 6-page thing, and they waited on till the 10th day. That said it was a timely manner. Wait till the 10th day. I guess. But that's what's in it. They put in there that they looked up a post about Mason Yancey's. They were inviting people to come and tell the commissioner's court how we felt about his unjustified jail death, and they took that to mean that there were 150 people showing up to with guns. No one has. No one ever has. Not one citizen, private citizen, has showed up to this commissioner's court with a gun. CJ doesn't count because he's an attorney. He's allowed to. The average citizen that comes to commissioner's court that's been coming for 10 plus years has never came with a weapon. But I know who has. I know who in 1988 walked into the clerk's office and did a horrible thing. And you know what protected him? His badge. Isn't that crazy? And he did some horrible things to innocent children. 2 innocent children. He was a monster. And his chief of police buddy protected him because he was a fucking Tarrant County sheriff. Man, I went back that far. And I want to tell him, leave me alone. Leave me out of your petty bullshit. Leave me out of your little ego trip that y'all have. Just accept the way I cuss at you. Just I accept the way that the reason y'all feel so big-headed and y'all got big nuts is because of them fake clown costumes you have on. The reason I have big nuts is because I'm a fucking citizen and I'm a free person. You know? And I stand on it. That was very frustrating. Because it didn't remain confidential. It did not. It did not. It made its way into an exhibit as evidence to revoke my bond. So, Galactone. I am not trying to hear it no more. I'm done with them this because all I'm doing is getting signatures. I'm getting defendants because I'm the plaintiff. All I'm doing is getting defendants. They're the ones dumb enough to do it. They're the ones that think that's little blue line bullshit and shut the fuck up. Let's do it. I got your back. And it ends. It comes to an end eventually. You know? Because what normally happens, what normally goes on, ain't popping off no more, homie. That's over with. It's a done deal. And I'm not trying to hear it no more. Because all I'm doing is exposing the bad people. I'm exposing the crooked. I'm exposing the ones that hide behind a title and are scumbags. They're not good people. But the fact that they can say certain things and influence and say you owe me this, you owe me that, right? But yeah, Tim O'Hare, ex Farmers Branch mayor, cost his city $6 million over 8 million over a 6-year period, or 6 million over an 8-year period. It's one of those. But that's what he cost him because he was trying to exclude a certain race from a certain area. Was his discriminatory policies. And he left. They kicked him out. Farmers Branch. Look it up. That's who runs our commissioner's court, Tim O'Hare. Bill Wayborn came from another fucked up place. They ran him off too. To where the news people, whenever he just recently passed away. I think it was the guy with Footwear Star Telegram. I don't remember his name, but he recently passed away. He asked him, "I want to know why y'all fired Bill Wayborn. Why y'all didn't fire Bill? Why he was allowed to resign? Why did he resign?" And the city, "We're not gonna comment anything. We're instructed to legal." And they asked him, "So you still support him?" "There's still a sign in my blah, blah, blah." So you already know. He's used to this. This is how it goes. And now he has a fucking weenie just like him right there. You know, that's how it goes. If you have a top guy that's used to doing shady things, that because this is what I tell people, right? And they ask me this, right? So if you have a kid, you have two kids, right? And two of them, they both do the same bad thing, and one of them you punish him, you take away his things, you send him to the room, and the other one you take him outside and beat him up and make him cut the yard, right? The one that you beat up and meant to cut the yard, he's gonna understood he did something wrong, he did something bad. The other one, you took his iPad or his iPhone and sent to his room, he's be like, "Oh, the only thing's gonna happen, he's gonna take my shit, I'll just get another one." What'd you teach him? What'd you teach him? And that's the problems we have in these government places. You got a fucked up dad that doesn't want to discipline the kids because he's a piece of shit dad. He doesn't know how to be a father. He doesn't know how to be a head of household. He doesn't know how to lead. He just knows how to follow what he's being told. Because once you follow the crowd or follow the leader, your statement about "I think on my own," you know, so it's just crazy, man. And that's why I don't like what's happening, because now it's the Tarrant County District Attorney's Office and the Sheriff's Office has teamed up against me now. Isn't that weird? Ain't that the beat all? I wonder where the conviction integrity units at. CIT, that's what they call it. They have like a group of people that are supposed to review the integrity of convictions, you know? But that never happens. Just like in the jail, there's a mysterious person that's organizes MHMR, but you never see her. They pay her so much a year, but you don't ever see her. But she's the best in her field, but no one ever sees her. Only the administration, I guess. Because none of the inmates know who the fuck she is. Just know that you hired her, paid her almost $1 million a year. But for what? No one sees her. No one knows shit about her. The heathen? Yeah. No, these dudes, no, no, that's not even the ticket, heathen. They use this to revoke my bond. They haven't even filed nothing. I haven't even dealt with the ticket yet. They use this ticket to revoke my bond. And I still haven't went to that court yet. I still haven't went to the place where I'm supposed to go deal with that stupid ticket. No, it ain't about the fine or whatever. We ain't even there yet. I want the evidence. So how are they going to prosecute me then if they're not going to give me all the evidence I need? Y'all going to have to tap out on that ticket then. But I'm still going to get that paperwork eventually. I promise you that. Yeah. Because I know some people in Austin that know how to file lawsuits on Kim Paxton to make him give up information that he's not supposed to keep. So I've already prepared for all that. All I'm doing is putting names. I'm just putting defendants because they're signing themselves, they're attaching themselves to this. That's all I'm doing. That's all I'm doing. They're attaching themselves to all this because that's who's telling them to do it. So the Tarrant County District Attorney's Office, thank you for adding yourself into the mix. I appreciate it. Because I have just started. Now, with that, my people, I pray that everyone has a peaceful day. And I'm glad I got to experience the devil yesterday, demons, all that, because it reminded me of where I did not want to be ever again. Where in my life I did not want to dwell in. Where in my life I did not want to feel comfortable being in. So that's why every day I wake up, I can say, I thank God that I have the ability to breathe, that I'm able to understand what I understand, and then I'm able to tell people enough to where they care. You know. And I also pray that everyone who's watching this, is blessed, and whatever your struggle is and whatever you're worried about, that God puts someone or something in your life, not to convert, not to change, but just to help. You know. I asked all this in Jesus' name. Amen, people. So y'all be safe out there. Film the laws, know your rights, and stand up, even if everyone else is sitting the fuck down. I spoke with the county prosecutor. Then I filed a motion for discovery. Yep, from what I've seen or not. No, I didn't. I wasn't. I did. But they won't give me the stuff. I already proved I wasn't guilty. I already went to court and proved that charge was stupid. But now they want to. I don't know. But I want the evidence. Y'all can't. Y'all can't make. That's like when the cop takes a picture, or a detective, or a lieutenant, or anyone who works in the government. You take a picture with your phone. Oh, that's a damn fly thing. You make a picture with your phone. You just created a public record. In the same sense, when you add these exhibits into a court case in a public courtroom, just remind you, they're not private. These are not, they're public courtrooms. The only thing you can't do in them is film. You can't get fucked. You can get fucked over in them, but they have to give you the shit they fucked you over with. That's Mando, right? They can screw you over in there, but they have to give you what they screw you over with. So, everybody, have a good day. Peace out.